Lawyers have priced themselves out of being able to provide justice for little people.
I spent $15,000 on an attorney in that first year. I decided that I had to represent myself in court because I was out of options.
The price that we've paid and what we've gone through is simply a nightmare.
My name's Jane Helen Gordon, and I'm 72 years old. I'm retired from university teaching. I filed for divorce in the fall of 1983. Because I was working at a very demanding job and because I had two small children, I had to get a lawyer. I just didn't have the energy, time, and stamina to handle it myself. So I had a lawyer. He didn't. My first husband kept bringing issues to court, and so I had to have lawyers constantly. Financially, it was devastating because I was the sole support of the children, and I was having to pay legal bills and do my job and house them and clothe them. And I think had he had a lawyer, instead of acting on his own behalf, he might have calmed down and he might have had someone to suggest alternate ways of resolving this. But self-representation, you're just like a crusader following your goal and never mind the rest of the world or the reality out there.
I think that the huge rise in the number of self-represented litigants in recent years is in some ways the great undiscussed issue of the legal system. My name is Julie McFarlane, and I'm a professor of law at the University of Windsor, and I'm now the director of the National Self-Represented Litigants Project. The numbers of people who are going to court without lawyers has gone up exponentially, and now we see more than half the people in Canadian family courts are there without lawyers.
The reason why I want to speak out and I need to stay anonymous is to protect my children's identity. The other reason is because I think I have an important story to tell, and I wanted to tell that story. I had to go to court on my own without a lawyer after all my funds ran out to pay a lawyer.
One of the things that we discovered in the research that we did with self-represented litigants was that more than half of that sample had begun with a lawyer. People had paid amounts from $10,000, $15,000, $20,000 all the way up to $100,000, and at $100,000 most of us can't afford to go on paying, and so they felt obliged to continue on their own.
When I was in law school, it was a very clear, your job is to advocate for your client, and advocate really is a nice way of saying you hold up your client as a paragon of virtue and you tear the other person down. My name's Rob Harvey. I'm a lawyer in Lethbridge, Alberta. I graduated in 1985. I do essentially nothing but divorce work. And I've been doing this, I guess, going on 30 years. So the typical traditional response of a lawyer in dealing with a self-represented litigant that they have frustration with has been to threaten them. Well, do what I want or else we're going to go to court and really bad things are going to happen to you. And I'm a lawyer and I'm going to clean you up in a courtroom. And so the neurological response to that is going to be increased fear.
Oh, you put all the documents out here.
Yeah.
Wow. These are all the documents from your case, from your struggle.
10 years.
But the place that I'd like to start is for you just to tell me, what is the conflict about? What is it that is the issue that keeps bringing you back over and over again to court?
Child support.
Child support. So this is after your divorce?
Guideline child support. So I have here some notes I wrote down so I can tell the judge, because every time I stand in front of the judge I get nervous and I forget what to say. Good afternoon, Your Honor. Please forgive me, Your Honor, if I don't... Sorry.
I've seen it. It's misery. I have had people hire me on a limited scope basis just to coach them to represent themselves, and I've talked to them later, and it is misery. You know, lawyers do add value.
So you have lost faith
I have
in the
lost
system
faith,
actually
yes.
working for you?
I have no hope.
I was spoken to very arrogantly and contemptuous by one judge who told me to shut up and sit down. I thought about suicide. I attempted suicide. I just wanted to find a way out of the situation. And with the love I have for my children now, had I taken my own life, it would have just made things hard for my children.
We have a procedure in the legal system which has been around for a very long time called summary judgment. It's a way of forestalling or ending a case prematurely before it continues through the processes, using up judicial and legal time. We found that there has been a huge rise in the number of summary judgment cases in the last 10 years, and that most of those cases are now being brought where there is a lawyer on one side and a self-represented litigant on the other. I read a reported decision from the Saskatchewan Court of Appeal which really exemplified and crystallized our concerns about this. This is a case involving a couple who were representing themselves, the Hopes.
Fay and I were very family-oriented. Our priority and focus of everything has been family. My name is Kevin Hope. I'm born and raised in Saskatchewan, in Saskatoon.
Come on, Mom, let the kids have a turn.
Fay and I had 5 sons. They're all adults now, aged 25 to 33. They're all on their own, doing well, and we've got 3 grandchildren. My wife and I retired permanently to the lake in 2013. We know the lake and we love it at the lake, so we bought the land thinking this is perfect to subdivide into lots and sell it to other people that can come in and build a cottage and enjoy the lake. Early on, when we bought the property to develop, we found that the rural municipality, the council, was a bit difficult to deal with. We self-represented because with $5,000 involved, if you hire a lawyer, you're clearly going to spend a lot more than $5,000.
Okay, so this is phase 2 of the development, running from lot 6 to lot 20, and it runs from north to south, and this is where we ran into the most difficulties with the municipality.
The rural municipality decided they weren't moving a road which they were legally required to move off of our property, and so Fay and I made the decision to self-represent and bring an action for damages for our losses because we weren't able to proceed with our development. The municipality's lawyers were trying to get our cases thrown out of court, and we were very discouraged when the judge essentially agreed with them on everything and found that our actions were essentially frivolous and vexatious, and threw our cases out and awarded them substantial costs, which probably were in the neighborhood of $75,000 that we would have to pay. And Fay in particular found it very, very stressful, and she was working long hours preparing now for an appeal, and she wasn't able to sleep. She was working herself to a frazzle, and then she got sick, and 2 days later she died. We don't know for sure, but I think it was a flu that she caught, and with the stress she was under, I guess her immune system basically went wild, and she went into septic shock, and there was nothing they could do for her.
In the case of the Hopes, the Chief Justice of Saskatchewan, he said this: "I can see no basis on which the history of the litigation involving the Hopes can operate as a basis for striking the claim." He continued, "All Ms. Hope says is that she and Mr. Hope would not have sued if they had not been wronged, and that litigation was not their first choice."
It's just something that was totally inconceivable to me that anything like this would happen. It's been a nightmare. I can't get Fay back. And she was my whole world, so. Can I say that she died specifically because of the litigation we were involved in? No, I can't say that. Nobody can say that. But I do feel that she would be here today if it weren't for the legal process and the stress that she was under. If I could go back 6 years and start over, I would have nothing to do with this development. I would have nothing to do with litigation. No amount of money is worth what I've gone through, and losing my wife. And here I am. I'm no closer to justice.
Self-represented litigants are powerless. But if we're going to respond to their enormous feeling of frustration, we need to start sharing the power. We need to start thinking about ways that judges and lawyers will do things differently.
The days when lawyers and judges basically own this system, those are done days. My name is Denise Barry, and I'm a lawyer with almost 32 years of practice experience. And I live on Gabriola Island, and I work in Nanaimo, British Columbia. And nothing I have done in those 32 years is more meaningful or more important to me than coaching and supporting self-represented litigants. There's nothing out there about the real nuts and bolts of preparing a case and presenting it in court. There's bits and pieces, but there's nothing comprehensive. So I thought, I'll write a book. I'll write a book that incorporates all of the mistakes that I perceive that self-represented litigants have made. The days when lawyers and judges basically owned this system, those are done days. What I'm doing, I think of as the new normal. This is Caroline Wilson, and she has amazed me and many other people in the legal profession by the success she's had as a self-represented litigant.
I decided that I had to represent myself in court because I was out of options. I thought that, there's got to be something out there for people that can't afford an attorney.
You know it's going to cost you some money.
Okay.
You know it's going to cost $80 to file this? Mm-hmm. Okay. And a divorce is worth that to you.
It's a bargain.
She was awarded costs against the other parties. In other words, even though she didn't pay for a lawyer, the other party was ordered to pay, I think it was over $3,000 of costs to her.
I'm Michael McDonald. I'm the Chief Justice of the Nova Scotia Court of Appeal, and as such, I'm also the Chief Justice of the province of Nova Scotia. This is courtroom 502. This is where typically the Nova Scotia Court of Appeal sits. We sit a panel of 3 judges. It might be nice if we could perhaps have self-represented litigants before their appeal in a workshop setting, so half a dozen or so come to this courtroom. We can show them where they should stand, what the process is, make sure they have a proper paper, any forms they need, any other tips they could use. We can explain all that to them, so it'll be less mysterious to them and less overwhelming to them when the day does arrive.
You know, it'd be interesting to start from the back end forward. How could I do a $10,000 trial? What would that look like? What would I have to do without? How would I pare that down? Because middle-class Canadians could afford $10,000 for a trial. Not easily, but they could.
We can no longer afford to try to solve this problem in silos, whereby the judiciary blames the lawyers for exorbitant fees and the lawyers blame the judiciary for their complicated processes, and everybody blames the government for a lack of money. We have to work together and come up with a collective solution.
There's a change going on in the justice system, and I would go so far as to say it's a paradigm shift. People can't afford lawyers any longer. And much as lawyers, or maybe even some judges, would just like them to go away, it's not happening. Self-represented litigants are here to stay.